And I'm confident my Democrat colleagues would be really pissed if the Trump DOJ subpoenaed 20% of the Democrats in the Senate and concluded with no basis in fact that the mere fact that they are Democrats demonstrates that they...
not clear,
Senator
so
Hirono
like
can respond, but
you
can. I'm happy to recognize you to respond, but I would ask you not to interrupt me because I am not interrupting you. I am certain my Democrat colleagues would be unhappy if the Trump DOJ... I'm asking you not to interrupt me, Senator Hirono. I did not interrupt you. I am speaking now, and I will recognize you to respond when I conclude in speaking. I am confident my Democrat colleagues would be deeply unhappy if the Trump DOJ subpoenaed 20% of the Democrats in the Senate and concluded the mere fact that they're Democrats means they are likely to be criminals. You know, it is an amazing statement that Democrats now believe that the fact that a member of the Senate speaks to the President of the United States is sufficient to subpoena their phone records and presume they are criminals.
Why don't we
because,
move on?
Senator, you don't get to say move on because you don't have the gavel, but I will say this. Sad to say, well, perhaps if you hadn't presided over a disastrous economy and an open border and wars across the globe, you might still have the majority, but you don't. And my point is very simple. It is not a criminal conduct to speak with the President of the United States, and it is ludicrous to suggest that it is.
And of course I didn't make... Thank you. I'm really glad that that the chair and others have expressed concerns about using facts in order to make decisions, so that's good. So let's look at the facts. Let's talk about those facts. Chief Judge Boasberg issued non-disclosure orders for subpoena seeking telephone records. My Republican colleagues object to the judge's decision. But then he issued these orders. When he issued those orders, he did not know that the phones belonged to senators because nobody told him. And that was the longtime DOJ practice at the time of his decision. Jack Smith testified to this under oath before the House Judiciary Committee last month. And if we have questions about that aspect of what was going on, we can invite Jack Smith to come and testify in an open hearing as he has offered to do. Meanwhile, as for the judge, he was told that President Trump or those who tried to help him overturn the election made or received calls from these phone numbers on January 6th or shortly before. Courts are required to issue non-disclosure orders when there is reason to believe that not doing so would lead to witness intimidation or evidence tampering. That does not mean, as Jack Smith testified last month. In fact, here's his testimony. This is his transcript of the testimony he provided to the House Judiciary Committee. He testified that the senators whose records were seized, he was not testifying that they were the ones who would tamper with evidence or intimidate witnesses, only that someone would. Instead, again, according to Jack Smith's sworn testimony, non-disclosure orders were sought because President Trump repeatedly tried to intimidate witnesses. We have all been witness to the fact that President Trump goes after people he doesn't agree with, and he is very busy targeting people. We know that. So if my colleagues want more answers, they should invite, again, Jack Smith to testify publicly as he has offered to do. Or at the least, they should read the transcript of his sworn testimony. We care about facts? Well, hey, here are facts that he's providing. If my colleagues are looking for someone to blame for their phone records being seized, they should blame President Trump, who tried to overturn an election on January 6th and called or had someone else call the senators in the process. But this impeachment crusade, this hearing, is not about supposedly judicial misconduct. It is about intimidating and threatening judges who have the temerity to apply the law to Donald Trump and render decisions that Trump doesn't like. Come on, let's face it. We all know that President Trump doesn't think that the rule of law applies to him. He can do anything. That's what he said. So this hearing is for show. And who's the audience? President Trump. If the standard for impeaching judges was that they issue decisions we disagree with, then I would call for the impeachment of the justices behind opinions like Citizens United, Dobbs, or the hand-picked judges in Texas who are the targets of so much judge shopping. But a judge or a justice's decisions should not be the basis of an impeachment, which is something the Senate has understood since the Jefferson administration. And that's why I, and so many of us, we don't call for judges to be impeached based on how they do their jobs and the fact that we disagree with how they do their jobs. And if we want to talk about judicial accountability, we should conduct further oversight of Justice Thomas's failure to disclose the many gifts he has received as an example. That's just one example. In the meantime, let's stop with these kinds of hysterical, and I would say dangerous attacks on the judiciary. And as for Judge Boardman, her sentencing decision is on appeal, and as the Chief Justice Roberts has said, the appellate process is the appropriate process. And that is exactly what is happening. I am running out of time, but I just wanted to ask Professor Vladeck. So we're sitting here spending hours talking about impeaching judges whose decisions we don't agree with. And there has also been criticism of Judge Boasberg for how he assigns cases in the U.S. District Court in D.C. And I think that there are guidelines on how he does that, and it's, I think, random assignments. And that's different. For example, I would say, you can explain further the difference between the random assignments we're seeing in D.C. and the judge shopping in certain district courts within the Fifth Circuit.
Sure. Senator, just very briefly, because I know time is short. So the D.C. District Court has a random assignment process. I believe this committee is in possession of a letter from the administrative office that walks through how that process works specifically in DDC. There's a Fox News story by a reporter named Brianne Deppish that I think concluded that, in fact, Judge Boasberg has a disproportionately low percentage of cases challenging Trump administration policies. That is different from at least what is the one district court left that has judge shopping, the Northern District of Texas, where it's still the case that 100% of cases filed in Amarillo, for example, are assigned to Judge Matthew Kaczmarek, or 100% of the cases filed in Wichita Falls are assigned to Judge O'Connor. And Senator Hirono, I think it's a relevant point because even as I think, have visibly been one of the loudest public critics of the practice of judge shopping, never did I call for the impeachment of Judge O'Connor or of Judge Kaczmarek, even for indulging this process, even for denying motions to transfer, even in the case of Judge Kaczmarek for taking a shot at me. Right? This is how the court system is supposed to work. When things go wrong in that process, we appeal or we reform. And just really briefly on the call records, that to me is the productive part of this conversation. If a majority of this committee, if the full committee thinks that the targets of call record subpoenas have a right to be notified, then so be it. And then that's a conversation about how we can change the law. That's a conversation we've had about foreign intelligence surveillance for the last 15 years. So I think we're trying to use the lens of judicial impeachment to get around the fact that there are actually meaningful substantive policy questions here that are much more fruitful to discuss.
I agree. Thank you, Chairman.
I would note that Professor Vladeck just said if a majority of this committee thinks that senators subject to subpoena should be notified that they could pass the law, well, magically we used a time machine to do that because Congress passed that into law in 2004. It is in the United States Code. It is black-lettered law, and Judge Boasberg disregarded that. Now, he did so at the invitation of Jack Smith. And I would say my Democrat colleague said, well, gosh, it's standard practice not to tell a judge the number you're subpoenaing. It is not standard practice to subpoena 20% of the Republicans in the Senate and the opposing party. And I'm confident my Democrat colleagues would be really pissed if the Trump DOJ subpoenaed 20% of the Democrats in the Senate and concluded with no basis in fact that the mere fact that they are Democrats demonstrates that they...
Not clear,
Senator
so
Hirono
like
can respond, but
you
can. I'm happy to recognize you to respond, but I would ask you not to interrupt me because I am not interrupting you. I am certain my Democrat colleagues would be unhappy if the Trump DOJ, I'm asking you not to interrupt me,
Mr.
Senator
Chairman?
Hirono. I did not interrupt you. I am speaking now, and I will recognize you to respond when I conclude in speaking. I am confident my Democrat colleagues would be deeply unhappy if the Trump DOJ subpoenaed 20% of the Democrats in the Senate and concluded the mere fact that they're Democrats means they are likely to be criminals. And I do want to note also, my prediction that no senator would mention Judge Boardman's name proved wrong with the penultimate Democrat speaker. Senator Hirono did mention her name, and 100% of what she said is the decision is on appeal. And I would welcome any of my Democrat colleagues to say that Judge Boardman's decision to deviate downwards by 22 years to reward an attempted assassin, the Supreme Court justice, is anything but disgraceful, brazen, and encouraging more political assassinations. To defend it as anything other than a complete dereliction and abuse of her oath of office. Senator Hirono, you're welcome to respond.
You know, you talk about using facts. Well, the law that we refer to is not exactly clear on who bears the responsibility for asking who the heck's records are being subpoenaed. And by the way, if you want to blame somebody for the fact that 20% of Republican senators' records were subpoenaed, you can blame President Trump because he's the one who was calling all of you, or he had his minions calling all of you. So there you go. That's all I have to say.
You know, it is an amazing statement that Democrats now believe that the fact that a member of the Senate speaks to the President of the United States is sufficient to subpoena their phone records and presume they are criminals.
Why don't we move
because,
on?
Senator, you don't get to say move on because you don't have the gavel, but I will say this. Sad to say, well, perhaps if you hadn't presided over a disastrous economy and an open border and wars across the globe, you might still have the majority, but you don't. And my point is very simple. It is not a criminal conduct to speak with the President of the United States, and it is ludicrous to suggest that it is.
And of course, I didn't make that suggestion, so that's why I'm saying, can we move on with this?
And while we're doing that,
Unnecessary
since
hearing.
Professor Vladeck mentioned a letter from Director Conrad at the Administrative Office of the United States Courts, I'd offer that letter that he mentioned as an additional exhibit.